Thank you, Bob.
Good morning. It's a pleasure to have an opportunity to pontificate. We're going to talk about the importance of the Microsoft case as a kind of a framework. And I'll do my best to stay within a reasonable amount of time. You can help me if you'll just keep your eye on that clock and let me know when 20 minutes have passed. I don't think we can talk about the importance of this case without talking about the future. Futurists tell us that it's a mistake to predict a future as if there were only one future. Actually, there are lots of possible futures. And so the way that we're going to work on this is to develop 6 scenarios of the future with regard to the Microsoft case and its impact on antitrust. It's always dangerous to predict the future. When the weatherman says there's a 50% chance of rain, he really can't go wrong, no matter what happens. Only if you're dumb enough to say it's a 100% chance of something are you likely to be proven wrong. So we'll stay away from 100%. And in a little bit, I'll offer you my own odds on things. But right now, let's lay out several different scenarios. One scenario will be that Microsoft wins a case. The other will be that the government wins a case. And within each of these frameworks, I want to develop rationalizations for how I arrive at my own predictions. Let's take a moment, though, to give you some background. If Microsoft were to win the case, basically four findings would have to be made by the court. Let me say also, in the event that a settlement occurs, you'll try to place the settlement into the framework of the 6 scenarios. It'll probably fit into one or another of the 6, and probably neither of the ones at the extremes. To win the case, you've got 4 separate claims made by the government. 2 of them involve Section 1 of the Sherman Act, illegal restraints of trade, unreasonable restraints of trade, and 2 involve monopolization. If Microsoft won a total victory, the trial court would find that there are no facts, insufficient facts to sustain these 4 claims. They'd have to say Microsoft did not willfully maintain its monopoly power in the market for PC operating systems. And Microsoft did not willfully attempt to monopolize and to destroy effective competition in the Internet browser market through a course of conduct that includes tying and unreasonable exclusionary agreements. And 3, Microsoft did not enter into exclusionary agreements that unreasonably restrain trade. And 4, Microsoft did not unlawfully tie its Internet browser product to its separate monopoly Windows operating system product. Okay, those are the 4 challenges that the government has put forth. In our first set of scenarios that Microsoft wins, Microsoft would be left free to engage in 3 different kinds of areas, at least. 1, to engage in agreements that its competitors view as exclusionary, not only its competitors, but a lot of objective observers or third-party observers. In the trial, just to give you a little more background on that particular item, the exclusionary agreements, in the trial, the government presented evidence, for example, that Microsoft entered agreements with AOL and Intuit, whereby their products would be well placed on the Microsoft desktop, which is considered strategically important, in return for their using the Microsoft Internet Explorer, the Microsoft browsing product, with the result that this would exclude competitors such as Netscape. And they also entered into agreements with Apple whereby Microsoft would continue to develop Microsoft Office for the Mac, which was Apple's major product, in return for Apple's agreement to make the Internet Explorer the default browser on all Mac operating systems. That's the type of evidence that was offered with respect to the exclusionary agreements. The second area that Microsoft would be free to work in is to incorporate what could be standalone application software into its operating system. Now, in the trial, the government presented evidence that the Internet Explorer and Windows, which is Microsoft's operating system, may be referred to as OS during the course of the day, that they are separate products, that the sale of the OS, a product with appreciable economic power in the market, was conditioned on the sale of the Internet Explorer, the browser, and that tying them together offered no benefit that could not be achieved by customers putting the two together themselves or by combining Windows with some other browser. And the third area that they would be allowed to do, they'd be allowed to bundle applications with the operating system at what appears to be a zero price. And in the trial, the government presented evidence that Microsoft, which it declares is a monopolist, and it presented some evidence showing that it's a monopolist, that they sold the operating system and the browser together, which is to say bundled, at a single price, namely the price of the operating system, such that the software was given away, and that it would recover its costs on this through a high price for the operating system. As a monopolist, it could set the price for the operating system. Since a competing software producer presumably needs to earn a positive return on each unit of software that it sells, the argument is that giving away the Internet browser effectively prevents entry into the browser market and therefore illegally maintains the operating system monopoly. Okay, that's the background of what Microsoft would be able to do if they win a complete victory. Now, in our first scenario, competition reigns. Microsoft wins the case, but it turns out that Bill Gates was right. Remember, he's talked about all these competitors who are either real or potential that are lurking, I would say, in his anxiety closet, but maybe they're real. And if they are real, maybe Linux and Java and AOL Netscape can accomplish a miraculous growth into a new paradigm, and lo and behold, within a short time after the case goes away, the market becomes far more competitive than it ever was. We would see a vigorously competitive operating system market and lots of innovation, prices going down. Microsoft would suffer the same kind of fate that IBM suffered after its trial, and when it got away at the end of the trial without a conclusion to the trial, justice walked away from it. Nonetheless, IBM fell back into the pack. So that would be the competition reigns scenario. And the historians who are reporting this in the future, they don't report whether or not Bill Gates gives up his lakefront home and goes on welfare. We just don't know what turns out there. So let's move to another scenario in which the monopoly from hell becomes entrenched. This is your worst case kind of scenario of what happens if Microsoft wins. And basically, Microsoft wins in court. It marches on from victory to victory, strength to strength. It quickly takes over the enterprise market, which is probably going to be a bigger market than the personal computer market. That's the market for networks in businesses and organizations, which right now is pretty competitive and not dominated by Microsoft. Microsoft has a plan, which they've announced, to move forward into that area very strongly, and people in that area fear that that will be one of the outcomes, that Microsoft will replicate its monopoly with PCs. It would continue, Microsoft would continue to learn from its competitors' software and make its own versions. It would bundle these with the operating system, price them at zero, and drive out competitors. The Department of Justice would become thoroughly demoralized. Its budget would be slashed by Congress amid charges of government waste and interference with the American technology juggernaut. State attorneys general would become quiet, having learned that big but unsuccessful antitrust cases curry little favor with the voters. Microsoft would continue to build its content providing business. Within a few years, it would dominate operating systems and applications and be in control or gaining control over new delivery technologies, such as handheld computers, TV, internet interfaces, voice recognition. When computers are turned on all over the world, the first thing that would go on the screen would be what Microsoft wanted to put on the screen. It would control the order in which browsers report information, and it would begin to dominate in the content of what goes on the internet as well. With its billions and billions of dollars of cash, it can buy up all kinds of different players. And in fact, Time magazine in the year 2005 called Bill Gates the most powerful individual in the whole history of the universe. By that time, financiers would stop investing in companies or products which were not fully sanctioned by Microsoft. Innovation would be completely channeled into products that Microsoft wanted to introduce. Prices of Microsoft products, of course, would go up. And Microsoft, dominating electronic commerce, would be getting a small transaction fee on a substantial and growing portion of the world's commercial transactions. Eventually a political reaction would set in. It won't get very far in this country because Microsoft would dominate our political system through its campaign contributions and charitable contributions all around the country. But on the international scene, various countries would start taking action. Now, in the third scenario, it's a little bit different. What happens here, I call it, we didn't get the monopoly from hell exactly, we got the oligopoly from heck. This would be the reaction of Microsoft's competitors in the larger computer community who get together as an alliance, possibly a couple of alliances. They don't compete head-on with Microsoft. They compete around the edges, and they have a very major presence, and they do everything they can, either as one closely coordinated alliance or maybe a couple of alliances. Maybe they members shift around from time to time. It wouldn't be real competition, but it would be some sort of a limiting presence. So let's turn now to the next set of scenarios where the government wins. Well, the first possibility, of course, is what we all recognize as a term of art. It's not in Black's legal dictionary. It's called the judge wimps out. Government wins the case, shows liability, but there is no significant remedy. Everybody knows the remedy is nothing but a slap on the wrist. One possibility is that this could occur because the case bounces back and forth to the appellate levels for years and years. And even though the trial is rapid, the case doesn't get resolved for a better part of a decade. If that occurred, you might just end up with a totally Pyrrhic victory. Microsoft loses on the law and wins in reality. Now, you could also have the government prevail, and the remedy that gets put into effect is a real loser. My scenario for that would be a remedy that's highly regulatory. That is probably a conduct-based remedy, one that requires intensive and long-enduring involvement by the judge, possibly with appeals going back and forth on various rulings. Everybody comes into court anytime anybody wants to do anything, and we end up with a de facto regulatory regime. The result of that would be that Microsoft becomes so bogged down that its energetic and creative people grow restless and they move on to some other companies, and Microsoft stock enters a long decline. And scholars, looking back, felt that the remediation of Microsoft was the turning point that led surprisingly quickly to the loss of American economic dynamism. On the other hand, while Microsoft's hands were tied by this regulatory regime, the rest of the industry had a lot of breathing room and the opportunity to flourish at Microsoft's expense. Finally, we have the scenario that the government wins and achieves its objective. Competition reigns. This is the scenario in which the porridge is neither too hot nor too cold. The judge, the Justice Department, the Supreme Court, everybody gets it just right. And I won't tell you what that means. We'll worry about that later. But it means the outcome is a highly competitive, innovative industry, prices relatively low, and lots of players. A diversified computer industry. Okay, so what are the probabilities? Well, who knows? Go ahead, Arvin. This is what I think, and we can argue about this, and as we argue about it, we should try to explain what our reasons are. I think that Microsoft has about a 1 chance in 3 of winning. And I think the chance of winning at the trial is lower than that. But the appellate courts are not going to be inclined to be friendly to the government. On the other hand, I think that in the long run, a government victory will be sustained. So I give it about 1 out of 3 that Microsoft wins, 2 out of 3 that the government wins. If Microsoft wins, and the scenario of Microsoft wins, competition reigns, I don't think that's real likely. It doesn't matter what these numbers are. It's really a question of likelihood. I think that's unlikely that competition will reign if Microsoft wins this case. If Microsoft wins, what are the odds that we'll either get the monopoly from hell or the oligopoly from heck? Maybe 1 out of 4. Government wins. Chances of either a Pyrrhic victory or that the remedy is a total loser, I think is kind of small. And that's an area where there's a lot of room for disagreement. Part of my reasoning is that I think as we get closer to figuring out exactly what the liability is, we won't know the liability until the courts tell us the liability. What's the rationale for developing a remedy? As we get closer to that, more and more attention will be focused on this issue. It has not been an issue in the trial, not one that's been developed yet. And there are a lot of folks out there who have knowledge, people in the industry on both sides. If Microsoft participates in the development of a remedy, we'll probably get a more reasonable, workable remedy than if they don't. But we've got a good shot of getting there. Courts also have a way of going back and revisiting remedies to try to make sure that they do work. And in one major antitrust case, Supreme Court 10 years later, after the initial injunction in the case, where there was a conduct remedy. The Supreme Court went back and said, that hasn't worked. We're going to make it into a structural remedy. And they did. So there's a lot of oversight. We've got a lot of experts. And this is an interesting case because so many people have had a chance to really get involved in the case on the outside that there's just a huge amount of information and analysis flowing in. But you could have a loser. That's possible. And then finally, you've got the possibility, which I think is the strongest possibility, of both a government victory and increased competition, a positive outcome to this whole thing. Let's go to the next slide. And just another way of reframing these same odds. In the event that Microsoft wins, I think that there's about a three-quarters that it'll be a negative outcome for competition. If the government wins, I think it's about three-quarters that competition will win. So, do you carry your umbrella on a prediction like this? I think these are odds that justify the government attempting to develop a strong positive remedy. Next. To try to summarize what I see as the importance of the Microsoft case based on this discussion, and I recognize that there are other issues that will be raised today. Some of them may well belong on this list, and some of these probably are not all that important, but let me run through them very quickly, again, to try to frame the conversation. I think that the viability of Section 2 of the Sherman Act in high technology industries is at stake, as Bob said. If Microsoft prevails, it'll be much more difficult to muster the political support for a large-scale monopolization case, particularly in a network environment, and particularly in industries that are undergoing relatively fast evolution. The concepts of essential facility and predation, I'm sure will be discussed later. I'm not going to get into them now. They may not appear as words in a judicial opinion, but these are the essential ideas in much of what this case is talking about. Whether these ideas gain more life in monopolization law or become further emasculated is one of the things that we will see. Tying arrangements. One of the interesting things here is going to be the extent to which courts are willing to get into the details of how an industry works, a high-tech industry. If you'll remember the consent decree that immediately preceded this case, the question was whether Microsoft, in violation of a consent decree, had tied the operating system and the browser. And the appeals court for the District of Columbia, I think, in a way, punted on the issue. What they basically said was, if the monopolist in a complicated industry like this can show one feasible reason why consumers benefit from a tying or from considering the product to be an integrated product, a single product, that's good enough for us. We're not going to balance out any disadvantages that might be there for the economy or for the public or for competition. So whether that is the right way to approach this sort of thing will likely be determined in this case. And if balancing is not required, then it's going to be extremely difficult for plaintiffs to win technologically sophisticated tying cases. Number 4, of course, is the remedy issue. If the government wins, the remedy will relate not so much to monetary damages, although monetary damages will be out there in the follow-on cases, the private cases. The important thing is the future structure and performance of what is surely among the world's most important industries. Over time, the case will demonstrate whether we can fashion and implement appropriate remedies in the context of high-tech industries. Now, the rest of this is comparatively unimportant, but let me mention them. As a procedural matter, the Microsoft case may tell us whether a monopolization case can be moved along fast enough to be relevant in a high-tech industry. You remember the IBM case went on for years and years, and a lot of people concluded that antitrust doesn't work. It's just too slow. But this trial was intentionally put on a fast track, and it has proceeded quickly through the limited number of witnesses that were permitted, and also by presenting direct testimony on paper and having the trial focus on cross-examination. The case may have some effect, breathing space, merely through its existence. That is to say, simply by bringing the case, forcing Microsoft to defend itself in public, to divert the attention of executives, and to bring a lot of facts into the public realm, that has had an impact already. You look at what the papers are reporting about a possible settlement on the focused on the exclusive agreements, and Microsoft is saying we're willing to stop doing what we've already stopped doing, which is what we stopped doing after the case became public. Two other points. I think that public relations is going to gain a whole new role in antitrust litigation. In cases after Microsoft, particularly also after Intel, where we had a very different strategy at work, public relations consultants are going to routinely supplement teams of lawyers and economists. You heard it here first. And finally, the electronic fingerprint problem is going to have to be resolved either by making it standard operating procedure to not put things in email in organizations that can imagine themselves as potential litigants, i.e. everybody. Or maybe we've identified a niche and somebody can go out there and figure out how to eliminate all traces of email from hard disks and from intervening computers all around the world. I don't know how that will come out, but certainly it's raised everybody's attention to the problem of email evidence. In summing up, I think that the Microsoft case may be deemed important simply because it's perceived to be important. For the first time in more than a generation, antitrust is discussed in homes and at cocktail parties and at symposiums, in part because of Bill Gates' extraordinary success and his talent for making enemies. And more importantly, I think it grows from the recognition that the nation is moving into a new era that will be dominated by the computer and the internet, and that a great deal depends upon whether that new era unfolds in a highly centralized or highly decentralized way. So competition policy, for so long ignored by the man on the street, has once again become relevant. Thank you.